Okay, let's talk about some history of dispute resolution and mediation. In your books that you have, it talks about several things and some old Greek law and some old Roman law. If you think back in time, though, you talk about alternative dispute resolution and alternative dispute resolution methodologies. The primary difference between alternative dispute resolution preferred methodologies and what happened in the past, well, let's talk about in caveman days, what was the preferred method of resolving conflict? What do you think was the preferred? Most of us weren't around during that time, although my staff has accused me of being around since then. But what was the preferred methodology of resolving conflict in caveman days? Physical. You whacked them over the head with a club, right? It was physical. That's how you resolve conflict. Violence. Huh. Not much has changed over the years, has it? We still... Byron, how often do you get people whopping each other over the head with clubs these days?
Almost daily.
Almost daily, and they use other things besides clubs, right?
Yes, sir.
They use what?
I would say guns, kitchen knives, ink pens.
Ink pens?
Pretty much anything that's handy.
Pretty much anything that will go into somebody?
Yes.
Okay. Well, so really, people haven't changed over the years, but you would have thought we would have gotten smarter, right? Well, there are two things that my dad taught me that I remember from growing up. One thing is that you can't fix stupid. Okay? Can't fix stupid. You know, you can teach the uneducated, you can educate the ignorant, but you can't fix stupid. Okay? And then the other one is the government will hire anybody, and so that's why I spent 10 years with HUD. But anyway, that's another story. And so what we need to do is we need to help people fight through the stupid. What in biblical days, an alternative dispute resolution that Solomon did. What was the story about Solomon and splitting the baby? Who's familiar with that story?
Cut it in half.
Okay, cut the baby in half. Okay, why? Why did he say cut the baby in half? Well, first of all, what was the preface to the story?
Well, there was two women who wanted a child, and I think one had actually lost her original child, and there was a claim that it belonged to both of them.
And so Solomon said, well, we'll resolve this. And he said, we'll just split the baby in half. Right? Okay? But Solomon, I guess he was as wise as Solomon, wasn't he? Okay? So what was his thinking? What was his thinking process? Which was what?
The focus on what each of them thought about the child, not about themselves.
Okay. And so
the value they placed on the child and not on themselves.
Very good.
Took it out of position and put it into intention.
Okay. So the mother, the real mother of the child was going to focus on the interest of the child, whereas the other lady, who really wasn't the mother, she was going to let it happen because she was only focused on her position of feeling that she needed to have that child, right? So, Solomon said, well, the real mother will come forward and say, okay, she can have the baby. And so, because he knew that the real mother, the real person that loved this child, would focus on the interest. And so the real mother gave up the child. And then, but ultimately got the child because Solomon then knew who the real mother was, right? Well, so you can see that conflict resolution has been with us through, ever since the beginning of time. Some type of ADR, alternative dispute resolution, has been with us from the beginning of time. Most of the laws that we have today are from modern law from England. In the United States, we have the Declaration of Independence and the Constitution of the United States of America and the Bill of Rights. But all of these laws that we have, does everybody interpret those laws the same way? No. Matter of fact, laws are, especially the law that I'm most familiar with is the Fair Housing Act and HUD, all of the laws involving housing. And it seems like there's just enough ambiguity in there on almost every section that you could question it, that you could have, and that's why you have lawyers representing plaintiffs and defendants, is, you know, looking at it, if you stand at it and look at it this way, it reads one thing, and you stand at it and look at it this way, especially if somebody's paying you, you know, enough money, and then you look at it this way and you see it from that perspective. I mean, it's amazing how much our perspectives change based upon how much of a vested interest we have in that particular position. We talk about the first uses of mediation. In most early societies, negotiation and mediations were commonly used methods to resolve disputes. Even in medieval Europe, priests, monks, and other officials of the early Catholic Church served as mediators in disputes, from commoners to monarchs to nations. And so you had basically you had the group that was considered to be neutral, although they were probably less neutral than other factions, but the religious sect that was used as mediators to mediate between all different factions. In Asia, mediation as a method of resolving dispute was preferred over those requiring a third-party decision. And then even President George Washington often found himself serving as a mediator between hostile factions when the executive and legislative branches of the new American government were formed. So all throughout history, we've had mediation. Most of you folks here are mediators in your own right. You have mediated things in the past. You just didn't know that that's what you were doing. And so our focus here is going to be to take that knowledge that you have as individuals with dealing with people, and to take that and to turn you into mediators of your own making.